Going to call this meeting, our 71st meeting of the Public Safety and National Security Committee to order. Welcome, Mr. Nicholson, Ms. Gallant. Good to have you with us, and everyone else as well. Pursuant to the order of reference, which we received 10 days ago on Friday, June the 9th, Bill S-231, an act to amend the Canada Evidence Act and the Criminal Code, protection of journalistic sources, is our topic for today. We are going to have two panels of witnesses. The first will be the sponsor of the bill in the House, as well as the originator of the bill in the Senate, and a collaborator on that bill. Our second panel will be members from the Canadian Media Coalition. I've just heard from the clerk that unfortunately Mr. Tom Hennefer, Executive Director of the Canadian Journalists for Free Expression, is delayed in transit. There's been airplane cancellations, so it is unlikely that he'll be with us today. And I just also want to note to the committee that we attempted to get witnesses from the RCMP, the OPP, and the Canadian Association of Chiefs of Police. However, due to short notice, as the principal reason, they're not able to be with us today. However, the Association of Chiefs of Police did submit a written brief. It is a fuller brief than what they were able to present at the Senate hearings on this bill, so I would commend it to your attention as well. So we're going to begin the first panel with Senators Carignan and Pratt and Monsieur Deltel. I understand that there will be expected bells to be ringing at some point for a House of Commons vote, at which point I will seek unanimous consent to consider going for a little longer, and we'll just see where we are when those bells ring. Who's going to begin? Monsieur Carignan.
Oui, je peux commencer, merci.
I'll begin, thank you. Mr. Chairman, ladies and gentlemen, committee members, first of all, I would like to thank you for having agreed so quickly to consider Bill S-231. The bill deals with a major issue, freedom of the press, one of the pillars of our democracy protected by the Canadian Charter of Rights and Freedoms in Article 2. As my colleagues will say, I am very, very deeply attached to our Canadian values and to the values in our Charter, and I was gutted when we heard that journalists had been monitored and surveilled. As a parliamentarian and as a committed citizen, that is why I decided to table Bill S-231. The intent of this bill is to deal with the legislative vacuum that creates a disconnect between our current rules and the standards of democratic developed countries. The very positive impact of this bill is
the fundamental role of journalists in our democracy. Protect the privilege of journalistic sources secrecy, which legislation had yet to explicitly acknowledge, and seeks to protect whistleblowers. Once the bill is passed, only a judge of Superior Court in Quebec, a Quebec court judge within the meaning of Section 552, may issue a search warrant relating to a journalist. Dès qu'une enquête aura été complétée,
as soon as an investigation is completed with a warrant, all information collected will be placed under the seal of the court, and none of the parties may be able to access it without authorization by a judge. As soon as an official wishes to look at that sealed information, a notice will have to be given to the journalist in question as well as to his employers. They will have 10 days to contest that move if they believe that the information might make it possible to identify an anonymous journalistic source. If the journalist contests the opening of that seal, it will be up to the person who is seeking the information to prove that it requires such information as an essential part of the investigation.
Part of federally regulated body, the organization or tribunal may raise an objection on its own initiative. S-231 protects the rights of all parties, enables journalists to protect the identity of their sources, and police authorities to complete their investigations. Finally, this act will put end to the potential fishing expedition or sources hunt. En terminant, je dirais ceci.
In conclusion, I will say this. The media play an essential role by disseminating and distributing information and by encouraging debate on issues of public interest. If journalists lack sources, if journalists can no longer alert people, they can no longer play a role that is so essential to our democracy, and Canadians will be the greatest losers. They will be deprived of their fundamental rights, the right to information. Anyone who abuses their power or the use of public funds will be able to continue acting with impunity, and once again, at the expense of Canadians. It's up to us, parliamentarians, to establish the needed measures to protect journalistic sources and thus to protect freedom of the press and the public's right to know. Thank you. Thank you. Senator Pratt. 5 minutes, please.
Democracy dies in darkness. For a few months now, this has been the Washington Post slogan. Like all slogans, it does not really need an explanation. It says it all. Without the spotlight shown by the media on public and private institutions, on those who govern us, citizens lack information and are therefore not able to properly play their role. Democracy collapses. Unfortunately, even major media outlets, those who have the most resources in terms of investigative reporting, those who are equipped with the most powerful spotlights, can't see everything. You first have to know where to look. Then there are always the shadows, the places where incompetent or dishonest people hide to do their dirty work. To spot these shadows and bring them to light, journalists need help. Let's call them lamplighters, people inside who secretly light a candle that pierces the darkness and alerts the media, telling them where to turn their spotlights. These lamplighters are the sources. Because they betray the incompetents and the cheats, sources often take great risks. If they're discovered, they may lose their job. The punishment may be even heavier if a criminal organization is involved. Journalist sources must therefore be protected. That means that journalists must be able to keep their sources' identities confidential, except in very special circumstances, even in a court of law, even in a police investigation. This is the only way journalists can reassure their sources and get them to come forward. Aujourd'hui, il n'existe dans la loi aucune...
Today, there's no protection in the legislation for journalistic sources. None that specific. Recent events, particularly in Quebec, where we saw journalists be the subject of broad operations of surveillance, are finding that their sources are being put at risk. If sources aren't confident that they will be kept confidential, they will say nothing. And if they say nothing, there will be darkness. What happened shows that the current legislation isn't enough to protect journalistic sources. Surveillance warrants are obtained too easily, and rules need to be clarified. That is the object of Bill S-231. I know that here on the Hill it's easy to criticize the media and journalists. We often do it, but we mustn't forget the essential role they play in democracy. As in every stratum of society, there are good journalists and some less good. Journalists are often very critical of parliamentarians' work, but thank goodness for that, because if they weren't, who would hold politicians to account? Journalists are, of course, on the lookout for what isn't going well. That's frustrating. But Otherwise, how would we know what isn't working well?
Without confidential sources, they could not play that role. Let me insist on this. Bill S-231 does not aim to protect journalists, but their sources. They are the ones that need protection because they are the ones that risk their friendships, sometimes their family, and their job because they feel duty-bound to inform Canadians of what they know. Passing Bill S-231 would be a historic step forward for freedom of the press in Canada, the most significant advance in decades, in fact. At a time when, south of us, the press has been attacked as it has rarely been before, Canada would send a powerful message on the importance it attaches to this fundamental right guaranteed by our Charter of Rights and Freedoms. More concretely, journalist sources, those courageous and lonely lamplighters, would finally be protected for the greater good of Canadian democracy. The flame of a simple candle is fragile, but as long as it is protected from the storm and extinguishers, it is enough to make light, and under the light, democracy shines. Thank you.
Merci, Monsieur Pratt. Monsieur Deltel.
Thank you, Senator Pratt. Mr. Deltel. Thank you, Mr. Chairman. It's a great pleasure and honour to be here today, especially 1 year after we both appeared before the joint Senate and House of Commons Committee on medical assistance for dying. It is with great pride that I testify here today as a Member of Parliament, as the sponsor in the House of Commons of this bill, and as a former member.
Colleague of the Senate, Senator Claude Carignan, who worked so hard, so fast, and so well with the support of colleagues like Senator André Pratt and all the others people in the Senate, work to table this important piece of legislature. So as far as I'm concerned, this bill is very correct because it respects every aspect of our society. Tout d'abord, Monsieur le Président, ce projet de loi définit ce qu'est.
First of all, it defines what a journalist is in a way that I believe is absolutely accurate. The bill is also founded on the protection of journalistic sources and not of the protection of the journalist, a distinction that is very clear and necessary because the journalist can make mistakes, but the source must be protected, and that is the purpose of this bill. We also recognize the merits of this bill. From now on, for example, somebody who can define how to proceed will be judges of the Superior Court. Experience has shown us that warrants were sometimes granted too quickly by justices of the peace or magistrates, and 90% of requests for warrants were accepted. There's also the issue of overturning the burden of proof. If a journalist is being investigated, revealing sources must be last resort.
It was a real turmoil situation to the journalist. Ce qui s'est passé, Monsieur le Président, c'est qu'en octobre dernier,
what happened, Mr. Speaker, is that last October we learned that Patrick Lagacé was the subject of 27 surveillance warrants to explain what he was like. He's a veteran journalist who has been working for over 20 years. He's recognized throughout Quebec as being a very well-established journalist. If we say it in military terms, he's known in all three forces, TV, radio, and air. He's very well known, very experienced, and he was the subject of 27 warrants for surveillance. That raised many questions in Quebec. To give you a bit of background, other revelations followed that led us to understand that some 15 Quebec journalists who were just as experienced as Mr. Lagacé, who specialized in investigations, were under police surveillance, be it Patrick Lagacé, Vincent Larouche, Marie-Maude Denis, Alain Gravel, Isabelle Richer, Éric Thibault, Denis Lessard, André Cédillo, Nicolas Saillant, Félix Seguin, Monique Néron, Joël Denis Bellavance, Gilles Toupin, Daniel Redon, Fabrice de Pierrebourg, and these are not all of them, were subject to police investigations either by the Sûreté du Québec, the Montreal Police, or the RCMP. We are seeing a situation that is completely intolerable and that requires a just and balanced reaction like Bill S-231.
Just remind you that 45 years and 1 day ago, a newspaper named Washington Post published a small article about a burglary who happened in the Democratic Party headquarters in Washington. And this Democratic Party headquarters was situated where? In a building named Watergate. 2 years later, all the world recognized what happened there, and all the world recognized the importance of whistleblower. So this is what this bill wants to protect.
Merci, Monsieur Deltel.
Thank you, Mr. Deltel. We'll begin with Madame Demar. First round of 7 minutes, if you will.
Thank you for being here today and your leadership in bringing this important legislation through the Senate and to us here in the House. I do have some questions. You've had the benefit of far more time to study the bill in the Senate than we've had here. Obviously, this is our first meeting on it. And it strikes me when I read the definition of journalist that in some ways it's somewhat backwards looking, because we do have journalism is certainly changing. We're seeing alternate forms of journalism, having podcasts on social media, blogs. Having said that, I also recognize the importance of defining what a journalist is to ensure that you're not using that term to actually hide organized crime or terrorism, and finding that balance is no doubt challenging. But I'm just wondering if you have any suggestions that we might be able to make that would allow us to maintain that public safety aspect of it, while also being a little more forward-looking in terms of the definition of journalist. Or if you think this definition covers it all, I'd be happy to hear that as well.
Merci pour votre question.
Thank you for your question. Listen, the notion of a journalist was originally broader. There are a number of comments from the Coalition of Canadian Media and also from police and law and order forces that found that the definition was too broad and included bloggers, for example, that worked free of charge, without compensation, in their basements. And that was a problem for police officers trying to enforce the law. At what point would they request a search warrant? And how would they know if it was a journalist, even if they took all due means to verify their professional identity? And so a number of law enforcement organizations called into question the enforceability of the legislation. And of course, there were also comments from the media. They wanted journalists who are earning a fair living. They wanted to protect their careers. It might be in a daily newspaper or an online blog. But these journalists displayed professionalism, and not everyone is wanting that kind of protection. So they suggested a definition of journalist, and I think that the Council of Print Media, among other organisations and stakeholders, reached a consensus vis-à-vis this definition. I supported the amendment, and on my way I went to the Supreme Court, and apparently the Supreme Court justices looked at the notion of journalism, and I read this in the National Post on my way here, and apparently there would be constitutional immunity when writers and orators interacted, even if they were heterogeneous and poorly defined, and whether or not they will be worthy of pledges of confidentiality. And this would considerably undermine the enforceability of the legislation, as well as respect for privacy, etc. And this particular passage that I quoted referred to sources vis-à-vis bloggers or professional journalists. So even the Supreme Court had trouble in this regard. And that's why I agreed to the amendment.
Concerns, I have to be honest with you, that I have is that we don't have anyone from the police side to testify before us today. They weren't available, so we've only got, we don't have the benefit of their testimony as we're looking at this. Did you consult with any of the ethnic media, for example, Omni TV, some of the more non-traditional media, in particular the ethnic media that we have a number of and Omni TV is a much larger one, but there are several smaller newspapers.
On a eu des représentants.
Well, there were representatives and stakeholders from journalists' associations, umbrella organisations for all journalists, in fact, including local media and ethnic media. Now, obviously, we're talking about journalists that are being compensated to a certain level, and that may include freelance journalists, but it's a very broad spectrum of journalists that is covered under this proposed legislation. And to my mind, there should be basic constitutional protection for all journalists, which exists in common law, for other scenarios where there might be similar occurrences. So the criminal code, as amended, would provide for very specific protection of journalistic sources, but would not rule out common law protection for other types of journalists.
Because I think one of the issues, I mean, you mentioned one broad organization that represents a number of journalists, but there isn't one specific organization that represents all journalists. I mean, we don't have the Canadian Bar Association, for example, or we don't have, because I can think, for an example, in my riding where there's a woman who runs an Indian online TV show. She does take advertising, so there is compensation involved. But I'm just wondering if some of the smaller media like that have been part of the discussion that has been had on this bill, as opposed to the larger media outlets and
Je
journalists.
dirais que les représentants de journalistes.
Well, there have been representatives from journalists, including the association, for which the name of which I forget, which is representative of most journalists, including small media outlets and ethnic outlets, not just the bigger outlets. And they really gave the point of view of the small media outlets.
I think that's my time.
Wait, Stephanie, that's it. Ms. Gallant.
Mr. Chairman, and I'll be sharing my time with Mr. Nicholson. First of all, I'd like to start by commending the work of Mr. Deltel and Senators Carignan and Pratt for your work in protecting independent and impartial journalism in Canada. Now, I agreed with what you said in the House, Mr. Deltel, that the passage of the bill is a good day for democracy and freedom of the press. But I want to focus on freedom of the press for a moment before we go into the nitty-gritty of the bill. And I'd like to ask you, Mr. Deltel, specifically as a former journalist yourself, if you could comment on what the government is proposing with respect to a $350 million slush fund. How would that impact the freedom of the press?
Well, I think it was a huge debate in the last general election, and we all recognize that all the parties has a straight position. It's very touchy when we talk about funding Radio-Canada CBC, because as we know, this is a press group, and a press group shall be independent from any political power. So the responsibility belongs in the hand of all journalists. And when I talk about the hands, I talk about the finger. The one who owns the pencil, the one who owns the machine, and the one who write or say something about the actual government. And it always have to keep in their mind that when you work on CBC, because I've worked on CBC in my 20 years career, I worked there for 2 years, and I know what I'm talking about. Always think of the interests of the people, period. You never have to add any political agenda, but for sure, when you see a huge debate surrounding this financing of this public institution, because this is a public institution, the responsibility belongs to every journalist to be frank, to be honest, to be equal, and to be non-partisan.
Okay. Now I'd like to go to section 488.02, where the bill refers to documents. It says any document obtained pursuant to a warrant, authorization, or order issued under the subsection, et cetera, is to be placed in a packet and sealed by the court. So my question is, how is it that the authorities come to acquire a document in the first place? How do they know a document exists unless the article which the journalist has written refers specifically to it?
Well, quite a good question, Madame Galland. I do appreciate. I will start an answer, but I'm sure colleague Senator Carignan will be more accurate than me. So what the bill is built is that to protect the whistleblower, but to let the journalist make his job. But if the policeman have any clue about the fact that he shall make an inquiry on a journalist, it must be first the last step of the inquiry, the last step of his will, and secondly, he have to convince a judge and a superior court judge, not a juge de la paix like we have now in Quebec. And as I said in my presentation, in the whole administration, if we pass the bill, 98% of the inquiry made by the SPVM, which is the municipal police in Montreal, got it from juge de la paix. So this is why we make it more tough for a policeman to make inquiry on a journalist, to be sure that this is first the last step of his job, and secondly, it's approved by a superior court. So this is my personal and first draft answer, but I'm sure Mr. Senator Carignan will be more precise.
I'm looking for the types of documents that would be used to justify the warrant.
In fact, en fait, c'est la définition de document.
In fact, it's the definition of documents that are in the criminal code. I don't have the specific section to quote you, but they're defined in the criminal code. Now, it may be a piece of evidence or computer-based information. A report containing information may constitute a document per se, and it may be sealed. And when I say sealed, it's put into a sealed package, and it might be a paper document or online. But the important thing that is a take-home message is that those issuing the warrant cannot look at this information before they request the opinion of the media outlet, and they might say, well, on my computer or on the hard disk, you're looking for X, Y, and Z, but in that hard disk, there is also a whole lot of other information that has nothing whatsoever to do with the issue at hand, but which may be considered as information that would lead to the disclosure of journalistic sources, so it wouldn't be relevant to the debate. And I really took a close look at what happens in lawyers' offices where, for example, their office is the subject of a search warrant and information is protected by their client lawyer privilege. And the purpose of this is so that client privilege isn't flouted.
To get at is how are the authorities getting the documentation in the first place to get a warrant issued if they haven't been doing something they shouldn't have been doing to know that there is something that you have or that a journalist has.
Oui, c'est sûr qu'ils doivent avoir, pour obtenir le mandat, ils doivent.
In order to get the warrant, there has to be reasonable grounds to suggest that evidence might be found suggesting the commission of a crime or an offence, and that evidence is likely to be found in the office or place which would be searched. But they're basic rules.
Very generous. Thank you to my colleague here.
I'll give you a minute.
Okay, fair enough. thank you, senators and members, for doing this. With the proliferation of information these days, this is becoming more critical to get something like this. Now, Senator Carignan, you said that this was very specific with respect to the protection of journalistic sources, but you made a comment that said their protection still exists throughout the common law. This is not the exclusive protection. Give me some examples of that protection that might otherwise exist that is not included in this bill.
La protection qui est reconnue actuellement.
Well, a kind of protection that is recognized vis-à-vis journalists is found in the common law, and a number of the criteria have been taken up here in this draft legislation. However, we have increased the level of protection to what currently exists by implementing a specific procedure for disclosure, and also reverse onus obligations where police officers deem that a piece of evidence may help them in an investigation, and where they would have no other means whereby they'd obtain that information or document aside from searching the journalist's office, for example, or in the offices of the media outlet concerned. Now, even if some level of protection currently exists, which is a result of all Supreme Court decisions over the years, we need legislative framework that is very clear for journalists, and that doesn't, of course, rule out protection for other kinds of journalists that don't fall under the definition, and of course the courts would make those determinations. Thank you. Mr. Dubé, 8 minutes. Thank you, Mr. Chair. Thank you, Senators and Mr. Deltel, for being here. It's a rare opportunity for me, and just give me a moment to come back down to earth, given the nature of this conversation. Now, unfortunately, we aren't able to hear from Law and Order because they aren't available, but for far too long in Canada, police officers' powers are too far-reaching, and it leads to problems like we've seen in Montreal or in Quebec City. There was cases with the RCMP. Mr. Bellavance can attest to this.
Today, actually, where Canada has fallen another 4 places after falling 10 places last year in the press freedom index, to number 22, which is very edifying. And given that the US and the UK have already had this type of journalistic shield law in place for many years, I certainly want to be on the record as saying we need to get this done as quickly as possible. Cela étant dit, messieurs, j'aimerais surtout, messieurs.
Now, having said that, gentlemen, and senators in particular, if you could respond, I have a number of questions. You've already heard from witnesses in the Senate, and you've read a number of the provisions of the proposed legislation. I'd like to start with Mr. Carignan. You've already alluded to this, sir. A journalist, for example, that would be under investigation for something that has nothing to do with the discovery of the source, but based on what you've heard from the Association of Chiefs of Police, is it your opinion that the bill in its current form would give enough flexibility so that there are no loopholes created? For example, you're investigating the journalist for other reasons, whether it be fraud or any other charges, and so that kind of investigation couldn't be used as a backdoor way of looking or searching for evidence. Do you think the legislation is tough enough vis-à-vis the police, given what you've heard from the witnesses? Well, I think so, yes. We heard from Law and Order associations, police services, organisations that testified that were very concerned about the notion or definition of journalist, and we arrived at a consensus, and police forces gave their input, and also the Canadian media outlets helped us to get a specific definition of journalist. And this has helped our police officers to determine when they request a warrant before a superior judge based on the draft legislation we have before us. Now, sometimes there are situations where a police officer might reasonably not be aware that he or she is in the presence of a journalist. And this might be in all good faith. That may occur. Indeed, I know that were there to be amendments that addressed that particular scenario, where, for example, for argument's sake, a police officer might be in a situation, despite all reasonable means, they didn't know that they were in the presence of a journalist and that they obtained a search warrant without being aware that they were in the presence of a journalist and that they didn't follow the proper procedure, well, that may need to be clarified, indeed. But to my mind, I'm sure you've met police officers over the course of your life. I certainly have. And usually they have a good sense of what you're doing before they come and visit with you.
I also wanted to look at Section 2, which states that this article applies notwithstanding other provisions to any other federal statute. This is the notwithstanding clause. I'd like to hear you talk about how important this is. I realized when we were talking about C-51 that when there is a form of, when there's a terrorist attack or any other incident of violence in Quebec or wherever we may be, the October crisis, for example, do you believe this is an important provision so that we make sure that in circumstances that are difficult in a crisis, we don't violate freedom of the press on the grounds of national security? Yes. I think this is a very important provision. Now, is it essential? Can it have unpredictable effects? Yes. The idea, of course, is to show that protecting journalistic sources is important, and it's something that needs to be taken very specifically and explicitly into account. But when it comes to interpretation, when you have particular provisions, how broadly do they apply? The idea was to show how important the protection of journalistic sources is. I would say the same. I think that this is a very important first step. We often say that trying to do better, leave well enough alone. What we're trying to achieve today is perhaps not the ultimate ideal. We have to think about possible repercussions of what we might be doing. I don't want us not to look at these potential repercussions by trying to save everything at any price. Two cases. Patrick Lagacé himself said a few weeks ago, and I quote, "In some circumstances, it might be justifiable to watch a journalist and to eavesdrop." So it's a question of common sense. As a former journalist, I always gave the following example. If on June the 5th, 1944, I had learned what was going to be done in Normandy, I had learned about D-Day, I would never have published it. It's just common sense. Mr. Pratt, could you please elaborate on the comments you made? I don't know whether your colleagues share the same view. You said that this is a first step. Of course, there's still a great deal to be done to fill out the legislation and make sure that journalists can do their jobs. Do you agree that this is a first step and there's a great deal more to be done? Yes. But we'll have to try the law out to see how it works. There are boundaries. Judges will have to interpret those boundaries. But I think, in my view, they are very solid boundaries, and in every situation, regardless of what they may be, any situation we can imagine, those boundaries will hold. If I may, in the time I have, when we look at the US and the UK, we're lagging behind in legislation that protects journalistic sources. Well, in my view, we are absolutely out of left field. We are nowhere near where we should be. This will take us into the vanguard. Of course, what matters is the application of the Constitution.
And a half minute, so I understand two of you are sharing, Mr. Spengman and Mr. Diorio, so you get 4 minutes and 15 seconds each.
That's very kind. Thank you, Mr. Chair. I'd like to thank all three of you for your championship of this bill and for bringing it to us. It's a very important subject. And I think, Senator Carignan, you said it very well when you said that the profession of journalism is really a pillar of our democracy. It's an institution that very much falls into the fabric of Canada's democracy. And yet, there are challenges. It's a complex subject. It's as much about the bill that's before us today, but it's also about the financial aspects of the profession, the financial challenges, the structural changes in the employment relationship that journalists face today. It's the changing media environment that really is transforming with so much information now making its way through social media to us. And I think I want to put to you also, thirdly, that there is a prospect of people using the vehicle of journalism to do us harm. I also sit on the Defense Committee in addition to this one, and you know, the whole paradigm of fake news and intentional misleading through journalistic channels is something that we need to take very seriously. I wanted to echo my colleague Pam Demoff's concerns that we do not have representatives from the police forces in front of us this afternoon, even though we have a written brief. But the subject matter is complex, and I think the committee, in addition to having the aspiration of being expedient on this bill, also needs to be mindful of the various facets and aspects of this important piece of legislation. And I'm wondering if I could ask you, perhaps Senator Pratt, if you could paint for the committee and also for Canadians your snapshot of the state of the profession as it exists in 2017 and how you see it evolve, and let's say maybe a short-term horizon of the next 5 years. What is journalism all about these days, and what does the committee need to be mindful of when we tackle a bill such as this one, even though this might only be a first step, as my colleague just pointed out?
In 30 seconds, yes.
You have minutes.
It's a difficult situation because there's not an obvious business model for journalism, so it is very difficult. But at the same time, I think if you look at it from if you look for a positive side, I think there is a positive side because there is demand for quality news. If you look at what's going on in the U.S. today, it is obvious that people are yearning for quality news. There is a lot of fake news, but people want quality news. So it's a matter of finding the right business model. And you can see that in the U.S., quality newspapers right now are doing quite well. The New York Times, the Washington Post are finding ways of getting back to in the black. So that's good news. But those are exceptions right now, and it's a matter of finding, how to get advertising back to traditional newspapers or news organizations, and that's very difficult. I've worked for 30 years for La Presse, which is now one of the more innovative news platforms in the world, really, and they're in difficulty, so it's difficult. If I might add a word about police forces, in the Senate committee where we studied S-231, we tested that definition of journalists with them, and they said they agreed that this definition alleviated their concern, that they were satisfied with it. I think it's important to know.
Could I take the remaining minute maybe to ask you just more specifically on the prospect of somebody using the vehicle of journalism and all its salutary aspects to do us harm, to deliberately send from foreign channels or through foreign channels or whatever the case may be, even domestic channels, news that is false. Not to say that this goes into the paradigm of terrorism, but simply deliberately misleading and false information about international developments, about domestic elements. How does your bill protect against that? And to the extent that we need to ask questions, what kind of questions should be asked?
Well, I'm not sure the bill would protect against this, but I'm not sure the bill has anything to do with that either. You know, one thing is for certain, the bill says that a journalist has to be his or her main occupation, and it has to be remunerated. So, I mean, someone who's not a real professional journalist will not be protected by the bill.
Mr. Chair, with your indulgence, if a foreign government, for example, hires a journalist in our sense of the term, to deliberately spread false information, are there any safeguards that we should put in place? Okay,
well, what I want to say about that is that, first of all, this bill is to protect the whistleblower, the source, journalist sources, not the journalist itself. We define quite clearly what is a journalist, which is, in some case, is not a real journalist. And also, three points is that, at the end of the day, it's a superior court judge who will decide if this guy or this woman is a journalist and if we can inquiry him correctly, if not. And let me remind you, all journalists are human beings. They are not away from the bill, from the law, any law. We shall respect the law in your activities, but first and foremost, we have to protect the whistleblower.
Thanks.
Oui, messieurs, je vous remercie.
Thank you to our witnesses. My first question is to Senator Carignan. A long time ago, when I was your law professor, you were asking me questions. Now, we've reversed that. Each of you has referred to Patrick Lagacé and other journalists, many of them. You described what had happened to them. There's an investigation going on by Justice Chamberlain of the Court of Appeal. He's being very diligent, and we should have a report within a reasonable period. So how would you explain that it would be reasonable to pass this bill before learning about the facts that led to the presentation of this bill? Well, the facts were cumulative. There were facts that referred to espionage, Joël Denis Bellavance, that had nothing to do with the Chamberlain Commission. I don't know if you taught me this, but the Keeble case in 1978, the Supreme Court ruling on the power of a provincial jurisdiction to establish a commission of inquiry in an area of federal jurisdiction. Now, even though I have a great deal of respect for the Chamberlain Commission, they have no power to act in an area that is under federal jurisdiction. It's up to us to remain within our constitutional area of jurisdiction, and that's the criminal code in this case. But wouldn't it be good to know what happened? Well, above and beyond the notion of what happened, we're learning a lot from the media. But notwithstanding what happened, even if nothing had happened, it still remains that we must protect journalistic sources, and we must have a mechanism that allows us to do so. Cases have gone to the Supreme Court, be it the Globe and Mail or the National Post, cases involving those papers where the journalists were investigated, spied upon, in order to get information about a journalistic source, or there were attempts to force them to disclose their sources. So if there were decisions that went to the Supreme Court, that's because there are problems, regardless of what's happening in the Chamberlain Commission. So, but he's doing a great deal. Yes, of course he is. But the result of his efforts is probably going to be directives on how to establish a bar for the police. But that still remains under provincial jurisdiction. Here we're looking at the criminal code. And you're talking about provincial and federal jurisdiction. Here we're talking about the criminal code, which is federal. In the provinces, it's either common law or civil law in Quebec. So would it not be reasonable to try to establish some protection under civil law and common law and see how that can be done concomitantly? I followed the work of the Chamberlain Commission. They've referred to Bill S-231. And I think if this bill were passed, the Chamberlain Commission would certainly take notice and would ensure that in any aspect of its work bearing on provincial jurisdictions, they would make any adjustments necessary. But what would happen if we waited for the report before this bill went forward? Well, we'd have at least 6 months in which sources might die, or information that's of public interest that would not be revealed because people would be afraid. The impact of disclosure in the Lagacé case, as the media testified in November, led to sources fearing for their lives, for their safety. So it would create an extension of that freezing, of that lack of disclosure through fear by sources. That's an impact that we can't necessarily measure, but which is absolutely tangible.
Just to say that l'un n'empêche pas l'autre. On se félicite de voir que le gouvernement.
But one doesn't prevent the other. We can see that the provincial government's taken the initiative it has, and that's good. But we should also congratulate ourselves on this initiative by the upper chamber. We are all unanimous in believing that this is a good thing to do, as are police forces and others. One doesn't prevent the other. We can't have people afraid to speak for the next 6 months.
Mr. Nicholson, if you wanted a couple more minutes, then we'll end this session.
I think I'll leave my questions to the next group there.
Okay.
Thank you.
The others? Very good. Thank you to our panel. That was very good. I think we could go on quite a bit longer. I know that members were waiting for a vote, and you may be up to date on this, but there is a motion on concurrence in the House, which will be debated for some time. So that's why there were not bells for a vote. That's also been fortuitous because Mr. Henhofer is en route from the airport. That is serendipitous for us to be able to continue with our second panel. So I'm going to suggest that we suspend for 5 minutes, and that Mr. Henhofer will arrive, and then we'll begin with our second panel. Thank you. Begin by thanking our witnesses for coming, both from the Canadian Media Coalition and also from the Canadian Journalists for Free Expression. We'll be able to go for maybe even up to an hour in this panel, if that's if you're good for that. I believe that there's a lot of questions from the members, and so we're able to. What did we decide about opening statements? We've agreed that 5 minutes from each of the two groups, and I'll be a little liberal with that. Small L liberal. We begin with the Media Coalition. Thanks.
Monsieur Chair and members of the committee, good afternoon. My name is Jennifer McGuire, and I'm the General Manager and Editor-in-Chief for CBC News. I wish to thank you all for this opportunity to address this important topic once again. I'd like to stress right up front how important we feel Bill S-231 is. I can say on behalf of our coalition of media organizations that speedy passage and implementation of S-231 would be a great service to the country. Why do I say this? Because investigative journalism is a vital component of a healthy democracy. It shines light on issues that matter, whether it's sexual assaults on Canadian campuses, questionable offshore tax havens, or unethical real estate practices. The sort of stories that pave the way for legislators to make better public policy. This journalism frequently relies on people who are brave enough to tell their stories and share their stories otherwise untold. Sources, and especially confidential sources. It also relies on a journalist's ability to protect these sources. Today in Canada, that ability is undermined because it is too easy for police to obtain a warrant allowing them to conduct surveillance missions on reporters. Late last year, we learned that some of Radio-Canada's top investigative journalists were being spied upon by the Sûreté du Québec. 5 years of their phone records were asked for. Some of the journalists had their locations tracked, and all of them had their freedom infringed upon. All because police wanted to know who their sources were. It's bad enough that these journalists were spied upon by the authorities, but consider the impact this news had on their ability to do their jobs. What confidential source would share information knowing they could not rely on any protection a journalist might offer? What whistleblower might decide it's better to stay quiet rather than risk being swept up in a police investigation? By scaring confidential sources into silence, we will never know how many cases of wrongdoing remain secret and how many cover-ups were made possible. Right now, the bar for obtaining warrants to conduct this type of surveillance is far too low. As just one example, dramatic testimony in recent weeks at the Chamberlain Commission in Quebec has shown us that even baseless sexual innuendo can be enough. Last Thursday, Radio-Canada's Marie-Maude Denis testified that one of the justifications made by police for spying on her was that she had an intimate relationship with another police officer who was one of the targets of the investigation. I want to point out that this was completely false and based on no credible information. That police made this allegation before a justice of the peace was shameful. That it was persuasive is frankly depressing. The clear implication was that successful women in journalism use sex as a way to get information. If you need proof that the bar for obtaining a warrant needs to be higher, look no further. Let me be clear, we realize that there must be exceptions. When a journalist is legitimately suspected of a crime, police may well have a good reason to track their activities. If it can be shown that there is no link between the investigation and the journalistic activities, then the suspect should not be able to invoke their profession as a shield. But as soon as the nature of the investigation has a link with the practice of journalism, then the protections of S-231 should apply in full force. And this decision rests properly with a Superior Court judge. Thank you for your time. I will pass to my colleague Michel Cormier.
Bonjour, merci de nous recevoir. Je suis Michel.
Thank you for having us here. I'm Michel Cormier, who's the General Manager, News and Current Affairs, French Services, and Marie-Maud Denier is the boss, and the boss of other journalists who were electronically monitored. Radio-Canada and the Canadian Media Coalition is pleased to support this bill sponsored by Senator Carignan. The key provisions of this bill deal with investigative journalism, and no one has challenged the fact that the Supreme Court of Canada has ruled in these issues. Law enforcement is not currently able to adequately protect journalistic sources. For the past couple of weeks, the audiences of the Chamberlain Commission gave us an opportunity of what motivated police officers to obtain wiretapping recordings of journalists and reporters, namely investigative journalists from Radio-Canada CBC. Their grounds were unreasonable and they were destined to failure. Regarding some of these journalists, well, it smacks of the abuse of these investigative journalists and their sources. There was an order from a Justice of the Peace to provide access to the telephones and cell phones of journalists, including their physical whereabouts in one case, and that had nothing to do with the crimes under investigation. And nevertheless, this jeopardized the identities of these sources. This has been obvious from the outset, as many police officers who've testified before the Commission stated that many had access to the wiretapping and they couldn't even demonstrate that it was warranted. So why request access to 5 years of registers? This question might have been asked by the Justice of the Peace and should have been asked by the Justice of the Peace, but clearly it wasn't, as orders were issued without further proceedings. I'd ask you to reflect for a few seconds on what that means. The police officers gained access to call logs that could reveal the identity of the confidential sources, although anyone could see right from the outset that the logs would serve no purpose. Breaching the confidentiality of journalistic sources throughout these court orders was not only completely pointless, but also a serious abuse of authority. Police officers in question were or should have been aware of this fact before requesting the first of the court orders, but the system completely failed to stop them. According to the Reporters Without Borders, Canada did not rank among the top 20 countries for defending freedom of the press this year. Several other democracies and even some US states have laws protecting journalistic sources. This bill must be adopted to change things, to ensure that the confidential sources will be protected and that never again will a police force in Canada be authorised to spy on journalists without regard for their sources and the crucial role they play in our democracy. However, the Coalition would like to stress that one of the proposed amendments creates a loophole in the protection of confidential sources. The new subsection 4.1 would exempt any order from the Act when it is alleged that a journalist has committed an infraction. If this amendment is adopted, it would suffice for investigators to claim that they suspect a journalist of having worked with a whistleblower for all protections afforded under S231 to be completely voided and for sources' identities to be revealed. This loophole would encourage unjustified allegations against journalists, whereas no investigations involving journalists in the past have ever led to charges being laid against them. Our proposal provides what we feel is a fair solution to this problem. It ensures that, in the case of journalistic work, the judge applies the test outlined in S231 before approving the warrant, while exempting investigations into common law crimes from this requirement. We're very satisfied with this bill. Not only will it put an end to abuses of authority and restore journalistic sources' trust in the system, it will also allow Canada to join those jurisdictions that legally protect all of these brave people who come forward to expose unacceptable situations and whose actions contribute to freer, more democratic society. That said, we ask that you pay special attention to the suggestions detailed in our factum.
Monsieur Cormier, on va continuer.
Thank you very much, sir. Mr. Henhofer, the floor is yours.
For being late to this. I think we've all had experiences with Porter Airlines before, so I thank you for allowing me to testify. I am speaking today as Executive Director of Canadian Journalists for Free Expression, CJFE, a non-profit, non-governmental organization that works to promote and protect press freedom and free expression around the world. We would like to use our time today to speak to the importance of passing the legislation now, the definitions in this bill, and the amendments proposed by the government. CJFE strongly supports Bill S-231, the Journalist Sources Protection Act. If passed today in its present form, Bill S-231 would be the country's first journalistic shield law, bringing us closer into compliance with international standards for the protection of sources. This is a badly needed bill, and its coming into force would be an important step forward for press freedom in Canada. As recent events in Quebec and elsewhere in Canada demonstrate, journalists today are vulnerable to arbitrary and summary treatment concerning search warrants and production orders with regard to sources. Bill S-231 was first introduced last November following appalling revelations that police had obtained warrants to track La Presse journalist Patrick Lagasse's phone and to monitor the phone calls of several other journalists. Canada needs this bill now more than ever. In addition to the reports of Quebec police spying, no fewer than 4 Canadian journalists have been arrested this past year. Vice News' Ben Maku continues to fight a court ruling forcing him to hand over communications with a source to the RCMP. Justin Brake of The Independent faces up to 10 years in prison for reporting on a protest. Corey Marshall, a freelance journalist in Montreal, was spuriously charged with unlawful confinement for simply covering a protest inside a government building, charges which were dropped in large part to CJFE's intervention. Photographer David Ritchie and Global News videographer Jeremy Cohn were arrested by Hamilton Police Services for their coverage of a pedestrian collision, and David Ritchie, it just hit the news today, has now been remanded and is still facing a court date for these charges now on July 20th. Canada fell 4 places on this year's Reporters Without Borders World Press Freedom Index, and in recent years we've dropped from the top 10 to 22nd in the world, largely because journalists in the country are not currently protected by any shield law. Despite our suggestions to improve this bill, which I will lay out in a second, we believe that this is a significant and necessary legislation and would impress upon committee members the importance of its swift passage. Let me be clear, Canada needs this legislation in effect today. Passage of this bill in its present form is only a first step to addressing many issues facing journalists in Canada today, however. This is because many of the definitions are still too restrictive. Further reforms will be required in the future so these protections reflect the reality of Canada's modern media landscape, but we do not believe that this should prevent the passage of this bill in this session. For example, the bill has a narrow definition of who can legally call themselves a journalist. We would suggest the definition should be eventually widened to reflect the emergence of newer practitioners of journalism, such as bloggers, and to include the many journalists who would not list the craft as their main occupation, such as student journalists and freelancers. They also deserve to be covered under this law. We endorse the amendment proposed by Matthew Dubé to broaden the definition to any person who contributes directly, either regularly or occasionally, to the collection, writing, or production of information for dissemination by any media, including newspapers, magazines, or other print media, television, radio, and other broadcast media, and any online or other media, or anyone who assists such a person. We see similar problems in the current definition of a journalistic source, which reads, a source that confidentially transmits information to a journalist on the journalist's undertaking not to divulge the identity of the source, whose anonymity is essential to the relationship between the journalist and the source. The deficiencies in this definition are vividly demonstrated by the ongoing case of Ben Maku of Vice News. Maku is currently seeking leave to appeal to the Supreme Court a court order to turn over his communications with a source to the RCMP. The order against Maku sets a precedent that is potentially ruinous and wide-ranging implications for press freedom and the integrity of journalism in Canada. While we strongly support Bill S-231, it must be stated that this will provide no protection in the context of the Ben Maku situation, because although his source refused to disclose his identity, he did not conform to the strict definition of a confidential source as defined in this bill. This leaves our country open to a situation in which a young Canadian journalist could soon be behind bars for simply doing his job. Clearly, this demonstrates a need for stronger legal protections. But again, we believe this can be fixed in later legislation and that this should not prevent this bill from passing in its current form. Requiring an undertaking of confidentiality is problematic, as sources by their nature are confidential. Journalists and their editors have a right to decide which parts of an interview are published publicly, regardless of whether that interview was with a confidential source or for attribution. The definition we propose is as follows. Journalistic source means any source that transmits information to a journalist. This is broader than the current bill, but there are two reasons for this. One, since a court or police agency cannot know whether a source is in fact confidential or not in advance, this should not be part of the threshold that triggers special care. And two, as in the Macu situation, compelling information about any source, whether or not they meet the strict definition of a confidential source, has a chilling effect. While this change may be outside the scope of consideration for the current bill, the protection of sources that are not anonymous must form part of a further discussion and factor into future measures to protect press freedom in Canada. The government proposes to amend the wording of Section 39.18bi to replace the word essential with important. We believe this change would undermine the principle of the bill and be inconsistent with existing protections. Existing jurisprudence says that it must be a last resort to force the media to pass over information. Setting the threshold for information at important falls short of this standard. The government proposes that the requirement to demonstrate that due consideration was given to all means of disclosure that would preserve the identity of the journalistic source become a separate criterion applicable at each stage of the analysis rather than a specific branch of the test provided for in Section 39.8. We support this change. The government proposes that the additional conditions for the attainment of a warrant would not apply in cases where the journalists themselves are suspected of criminal activity. This is meant to prevent the application of Bill S231 in a context outside of journalistic activities. The Media Coalition has offered remarks regarding this matter and has offered a suggested amendment, both of which we strongly endorse. The government proposes that the precedence clauses of Sections 39.12 and 488.012 be withdrawn from the bill and has expressed its belief that these clauses would unduly affect privacy and national security laws. As the wording of Section 39.18bi already provides for the disclosure of information or a document that is essential for public safety, we believe the government proposal would unnecessarily undermine the effectiveness of the Act. We thank those who spearheaded this effort, including Senator Carignan and Mr. Deltel. CJFE would also like to commend the Liberal government for its support of Bill S231. It is a promising, concrete follow-up to Prime Minister Justin Trudeau's previous strong statements of support for press freedom in Canada and will help establish Canada's position as a world leader on this issue. Thank you.
Thank you. Just before we begin with the round of questionings, I just want to put Monsieur Pierre Roy on notice that I think the committee may want your comments on the suggestions around the amendments, just as the lawyer helping the coalition. If you'd like to make them now, you'd be welcome to.
No, since I'm a litigation attorney, I was told that I should not address the committee unless asked a direct question because I would use everyone's time. So I will answer only legal questions that my colleagues here are not able to answer to your satisfaction. Thank you.
All right. So just, if you would like chance to comment on those things. You may just, I want you to think about it because I think we could take some time to do that.
Thank you, Mr. Chairman.
We're going to begin with Mr. Picard.
Merci. Je vais partager mon temps avec mon collègue, M. Arsenault.
I'll share my time with my colleague, Mr. Arsenault. First question, and welcome. Thank you for your time here today. From the outset, I'd like to point out that I respect our journalists and reporters, and in a former life, I worked alongside a journalist and helped train a journalist. It's an essential profession. We have to do our best to help them in the course of their work. However, the bill's purpose is to protect sources. We've talked about journalists for the past hour, but we essentially need to protect the sources, and we need a contemporary approach. Do we appreciate what the Chamberlain Commission is doing? What are your expectations vis-a-vis the outcomes of that hearing? Response: well, there are journalists testifying before the Chamberlain Commission. I see no incompatibility between this bill and the work of the Chamberlain Commission. There are journalists working across the 10 provinces of Canada, and although the Commission deals specifically with the work of journalists in Quebec. And from the outset, we have always wanted the Chamberlain Commission to not focus on the work of journalists, but explore what occurs when warrants are obtained to determine whether improvements can be made to those procedures, whether by justices of the peace or Superior Court justices, as is set out in this proposed legislation, or, for example, regardless of any political influence. And these are issues that typically have to do with matters that come before the Commission. Now, as we can see in the legislation, we want to provide for a number of safeguards when it comes to the obtaining surveillance warrants and what criteria need to be met before a warrant is issued. And we do hope that the Commission will address this issue, and based on what we've seen so far, it seems that the Commission is addressing these issues, broadly speaking.
Thank you. I don't have much time left, so it'll be a short question. The main purpose of this bill is to protect, among other things, information that is confidential. It has to be protected, of course, but also the public interest has to be protected. So those two notions can be contradictory. I'm going to put my question backwards. I don't know who's going to answer it, perhaps Mr. Cormier. Am I right in believing that this bill would not protect sources absolutely? Is that correct? Does it protect sources absolutely? Well, we talked about a potential amendment to ensure that it would provide absolute protection. This might be a good opportunity to ask Sébastien to explain what that amendment would consist in. In our view, it would improve the bill. You're quite right, Mr. Arsenault. It does not provide absolute protection. Far from it. So, for example, could you give a practical example where we might say, here is an instance where the journalistic source isn't protected? 2010 National Post case would be dealt with in exactly the same way as it was before, even with this bill. Since the Supreme Court has done, this bill would allow the balancing of certain interests, and the source would be protected only until a judge deemed what that balancing act was. Once a police officer shows that the information is essential for solving a crime, it would be disclosed. You are referring to the National Post case that came before the Supreme Court in 2010. I'm looking at page 2, authorization, paragraph 8. The court, the organization, or the individual can authorize the disclosure of information or documents if it believes that the following criteria are met. The document and the information cannot be obtained by any other reasonable source. Public interest in the administration of justice is more important than preserving the confidentiality of the journalistic source, provided that the information is essential to the case. You know that Judge Abella did not agree with the Supreme Court view, and that's the crux of it. That's what we're getting at. At the same time that the Supreme Court made that ruling to go beyond protecting the source, there had to be a central issue. The information had to be central to the case. If it is simply peripheral to the case, then there is no need to breach source confidentiality. But if the information is central to the case, then source confidentiality can be breached, and that's the crux of it. Except that the Whitmore test, which was cited in the National Post case, did not hinge on the central nature of the information. I'm not a constitutional expert. I don't want to take the committee's time, but we also have to look at the National Post. We have to look at the National Post case and the Lessard case combined. The central nature of the information held by the media is also central to the Lessard case, which I believe provides a synthesis of the jurisprudence of the past 25 years. If I might answer something that might help you understand, National Post, that ruling can only be applied tangibly if the policeman arrives at the newspapers' offices with a warrant to seize the computer.
To have the privilege recognized. But what's happening right now is that police officers are obtaining phone registers without the journalist knowing. You'll learn about it 5 years later when all the names of the source are disclosed, and National Post cannot be applied, and that's the main problem that this bill is fixing.
C'est l'affaire Lagacé, entre autres.
Toutes les affaires récentes sont des affaires de...
All these cases deal with secret warrants. Thank you, Mr. Arsenault.
Much. I think there's probably a consensus that the bill's not perfect, but we've got to move forward on this, or we basically will have nothing. And so the question I was going to ask in the previous witnesses, I'll publicly ask you, Ms. Maguire, is that we've heard that Canada is far behind a lot of countries, the United States, Britain, others. Would this bill, in its present form, would this point make us basically consistent with what the protections are in place in the United Kingdom and the United States? Or would you be in a position to answer that? I don't know, you know.
Yeah, I'll just defer to Sebastian in terms of the benchmarks worldwide, but it's our view, and it's the view of the coalition overall, that this represents a significant step forward here in this country, both in terms of the level of oversight in terms of the judicial intervention, and also reframing the process in terms of access to source information.
I'm pleased to hear that, because it seems to me that the longer we go without something written specific, the more difficult it will become in the future for just some of the reasons that Monsieur Pierre-Roy mentioned. Monsieur Cormier, you mentioned with respect to one of the sections of the bill, specifically the bill for which there is an amendment now that deals with the commission of an offense by a journalist. I just wanted to make sure I understood. Are you satisfied that the amendment that's provided by the government is good? Or, in fact, I'll get to you on this one, Mr. Hanaffer, in a second. What was your comment with respect to the amendment? Was that it was good or not far enough?
Well, we want to make sure that, you know, a police officer cannot just go to the judge and argue that just because they believe that a journalist has participated in a crime committed by a source, that's enough to have a mandate of inquiry. You know, we would rather have more safeguards into the process and make the role of the judge, you know, in layman's term, stronger. But maybe Sebastien can argue the finer points of law on this. But basically, that's kind of the gist of it.
Fair enough. I suppose one of the safeguards that we heard is that they are now, these warrants will be in the hands of a superior court judge, which is one more level of responsibility. Mr. Hanaffer, you said in your comments that you mentioned that, and then you mentioned that you may have your own amendment with respect to the section and I believe this is the section you're talking about, the one where there's a suspicion of an offense created by a journalist. Is that the one that you said you have a specific amendment to?
Yes. I mean, we certainly feel that if the police suspect that a journalist has actually committed a crime, that, you know, this type of immunity would not apply in that case. But we, again, to echo what the Media Coalition is saying, the fact that there may be suspicion that a crime has been committed, a source may have committed the crime, having that in there can completely invalidate the entire the strength of the bill if there's no protection just because a source has potentially committed a crime.
My colleagues and I are new to this committee. This is my first time on this committee, so you may have distributed that amendment. Do we have the amendment for Mr. Hanaffer with respect to that?
We haven't supplied an entire amendment. We deferred to the Media Coalition in that regard.
Fair enough, then. Thank you. Those are my questions, Mr. Chair.
Okay, Mr. Toubé.
Oui, merci, Monsieur le Président.
Thank you, Mr. Chairman.
But I'll hear the others as well on this. This idea of the definition of a journalist, because one of the things obviously there's evolving media landscape. There's freelancers who have different tools at their disposal to protect themselves. So, for example, I say this with all due respect, a journalist working for a larger media conglomerate probably has more legal tools at their disposal to protect themselves in court. And also, just So I'm just perhaps want to hear you a bit more on that and understand, in particular, when we look at, for example, there's been many interveners in the Ben Maku case because that's been required, given that he hasn't been able to, or he wasn't at one point able to muster up the appropriate resources to defend himself. So how important is that?
I think that really is crucial. I believe that the bill in its present form, again, is still worth passing. I think that I would strongly recommend that we do adopt this, or that the committee adopts this amendment from Mr. Dubé. You know, a lot of the time there has been, I've heard people say, just because someone tweets doesn't mean that they should get the protection of this. Just because someone is a blogger, it doesn't mean that they're necessarily a journalist because they maintain a blog, and that should prevent them from getting this. I have more faith in the judges in this country to be able to distinguish between someone who has tweeted occasionally or had a blog or something like that who would claim these decisions. I believe that the judges in our country are well enough trained to be able to tell the difference. But the fact is that, you know, the nature of journalism has changed. Many journalists now are freelancers. They are not getting paid for this as their primary job. They may be doing, you know, a lot of journalists get 60, 75% of their income from writing, you know, technical manuals or writing speeches or doing things like that, and then the rest of their journalism is a passion project. I mean, if you look at there are organizations out there like Discourse Media on the West Coast, the Halifax Examiner on the East Coast, Vice News in Toronto, Canadaland, which everyone's familiar with, that rely on freelancers, many of whom might only write 1 or 2 stories for them a year, but those stories could have extremely important impacts on Canada. And they oftentimes, depending on the type of outlet they're working on, the stories they're working on, they will have confidential sources that they need to speak to in order to get this information. And yet, they would not be covered by this very narrow definition of a journalist, which is why we feel that it just needs to be somewhat broader so that it is left up to a judge, and a judge can make the decision as to whether someone actually should fall under this protection.
If I may, before we hear from Ms. Maguire, just for the example from Canadaland, for example, would be, and I mean, I don't want to get into the weeds of, because I know journalists sometimes will argue who broke the story first and so forth, but they had a large role to play in the Gian Gomeshi affair. So I think that's a great example.
Absolutely, and I mean, I'm in a very privileged position in my job where I get to know, you know, probably the majority of journalists, at least in Toronto. So I know a lot of the people who write for them, and you know, one of their main freelancers at the moment is a guy who his main career was as a political staffer, and then he decided to gradually get into journalism. And he's broken some very interesting stories on the rise of the alt-right in Canada and some dangerous extremist groups in that side. And he would not have been able to talk to those people had they had the fear that they were being spied on in their conversations, because all of his sources are confidential. And again, he would not fit into the definition of this journalist. And Canadaland is just one example. There's many others.
It's easy. It's tangible for folks.
Yeah, including the CBC, who also uses freelancers.
Ms. Maguire.
Yes, freelancers connected to the CBC would be considered part of the CBC for the nature of this exercise. I hear the point, but I think also the reality is a lot of the investigative journalism in this country would be captured by this bill, and I think in terms of the greater good, it's a really positive step forward.
How much time? Thank you, Chair. The other, it's a question I raised on with the first panel, is if you go to Clause 2 of the bill, which I'll read it out there. So this section applies despite any other provision of this Act or any other Act of Parliament. And the question I posed to the last panel was just to nail down the importance of that, given that often when we are in periods of crisis, or when there's whether it's a terrorist attack or some kind of natural disaster, or something like the October crisis in Quebec, for example, where when these crackdowns happen, journalists are often collateral damage. So how important is a piece like that in a bill like this to make sure that there aren't any loopholes that allow a crackdown later on from other legislation, or something like C-51, for example?
Well, if there are questions of national security or a crackdown like the October crisis, it's the protection of confidential sources seems like a small element of that. I don't know how that would, you know, we have the Constitution, we have the Bill of Rights. I mean, you know, what supersedes what would be quite an interesting question, but I think, you know, for the immediate purpose, it's important to pass this piece of legislation. Even though it's imperfect, we have all issues with it, but I think we have to establish that watermark quickly right now, and then the other issues, I think, will still be out there and can be dealt with later.
And again, I agree with this. This is, you know, this bill is 80% a step in very much the right direction, and there's just a 20% there of ways that it could be improved. But we should not let that 20% prevent its passage. But I think that, you know, in regards to this, a lot of people would argue that ISIS is a crisis that the country is dealing with right now. Some other people may not feel that way, but Ben Maku was able to get extremely important information about this terrorist group and disseminate it to Canadians, including the security forces, because he was able to speak to a source who believed that his communications would not be released to the police, would only be sent out to the public in according to the terms of what they agreed on. If Ben gives up his notes eventually, then all of a sudden those types of sources will dry up and Canadians will lose that. So that's just one example of how important it is that we do maintain that balance and that respect for the right for journalists to do their job.
I just have one final question.
Mr. Nicholson was very underutilized and generous, so if you'd like to keep on going for all, that'd be fine.
I just have one last question, if I may.
Thanks, take your time.
The last question is just in terms of the fact that there's a lot of stories that have come out in the media, and one that's referenced constantly, especially for those of us from Quebec, is Patrick Lagacé. But this isn't something new, so I just maybe want to hear folks on how overdue this is, sort of in the same spirit as the question Mr. Nicholson asked, which I was going to ask too, which is we're sort of behind a similar comparable countries.
I'll take that one. I mean, it's not just overdue, it's the fact that the current state now has dried up a lot of journalistic sources. We have lost sources at Enquête who've disappeared. People will not talk to us that we believe would have talked to us otherwise because they fear being exposed. And the last thing is that you have, you know, it's the records of 5 years of our best investigative journalists in our most prominent program that have been surveilled. So you have tens and tens of sources now that live in the fear that they will be exposed, notably in front of the Chambellan Commission, who've been fighting to be sure that their names remain secret. So this is the actual effect. It's not just a hypothetical effect. There is a real effect now in not passing this legislation. So that's the best argument I can make.
And I'll put an accent on it sort of outside of Quebec. When we were doing investigations into sexual harassment within the RCMP, we had more than 50 sources within the RCMP tell us that they were more afraid of the climate and the internal climate within the organization than what they were dealing with in terms of a criminal activity outside. So the act of convincing a source to talk is an act of trust, and it's an act that's built over time, and one source talking and one story can lead to more sources coming forward, which is absolutely what we saw with the upselling of banks, which I think we had a committee hearing on that last week. So I think it's really important to understand that the impact of the chill affects the ecosystem overall, not just what was happening in Quebec.
And to bring in the international perspective on this, you know, for decades, there have been these protections in almost every other Western democracy in the world. Germany, the UK, Australia, Holland, 37 states in the United States all have these protections. Basically, almost every country in the European Union has these protections. It is a dark spot on Canada that we do not have a press shield law in this country. So this will absolutely bring us in line with international norms.
Thank you, Mr. Dubé. And Mr. Spengerman.
Chair, thank you very much. I've asked this question earlier to colleagues who were in front of the committee. I'm wondering if you could just describe for the committee and for Canadians how you see the state of journalism today in 2017. We talked a little bit about the pressures, the financial structural changes in terms of employment contracts. Some members have had conversations with stakeholders like Unifor who are quite concerned from the financial side about the sustainability of the profession as independent, as structured basically as a pillar of our democracy. Where do you see that go in the next, let's say, half decade or so? What's the current trend? And I see this bill as an element of protecting the profession, but there are other components that the committee should be mindful of as we deliberate what we do with this particular instrument.
So we're seeing clear fragmentation in the environment around journalism. You have multiple sources of information, and you have people choosing to only go to certain sources that sometimes just reaffirm their own point of view. But with the rise of sort of digital and social channels, you have incredible reach. So the ability of a story to have impact and reach more people is profound, and it's like it never has been before. So, is it complicated in terms of the business model? Absolutely. We're seeing that in the private sector, particularly with newspapers. In the public sector, we've had our own issues with sort of shrinking budgets and trying to do more because you're feeding more digital platforms all the time. But I will tell you that all of the research that I've seen, the RTNDA just did a recent study that shows that trust in media, in legacy media, is actually growing slightly in this environment that is cluttered with all kinds of disinformation as much as journalism. So I think the promise behind the brand in journalism becomes more important, but the business case is not solved, and there's no sort of solution on the horizon that we can see.
Could you elaborate briefly on that study you referred to? Is that based on survey data from basically that reflects the opinion of Canadians?
The RTNDA, which is one of the journalism organizations in Canada, did a survey about trust in media recently. And one of the findings that they found is trust in mainstream sources of media has increased in this age of fake news, that kind of thing. I'm happy to get it if it's of use.
And are you able to comment on the state of the profession in terms of people enrolling in journalism programs and what incentives this bill might provide to support Canadians in a decision to seek a career in journalism?
I think it's probably unrelated, but we have an obligation as journalistic organizations to connect not only with schools to encourage people to consider journalism as a profession, but also invest in critical thinking and journalism education in terms of how to consume media. And we do that, and we're doing more of it moving forward.
Well, just related to that, I mean, the fact is that in this environment of fake news, the only thing we have is our credibility. That is the most precious thing we have and the most fragile. So if you make a mistake, it has even more impact than it may have had before. So, you can be assured and confident that we are so careful when we publish information that is taken from confidential sources that it's been checked 2 and 3 times to make sure it is in the public interest and it's accurate. If not, I mean, it's a huge setback for us. So that's the commitment we have, and I think it's even more important for us now in this new environment where so many people who actually do whatever they want or produce fake news.
On the subject of fake news, which I think is in the forefront of the minds of many Canadians, how are journalists protected against sources that are deliberately created to spread fake news?
Well, we never rely on one source. The first rule is minimum 2 sources and more if it's even more sensitive. I mean, and a source is not just somebody that shows up one day and then you publish the stuff. These confidential sources that we use, usually we cultivate for weeks and months, sometimes years. So we get to know these people to make sure that they're trustworthy, that what they actually tell us is true, is believable. So we have all kinds of safeguards to make sure that we don't fall into that kind of a trap.
I'll just add to that. Any piece of investigative journalism is built on a mountain of information. That includes documents and other kinds of source material in addition to people. With a touchy investigation, we do more than double source. We'll have multiple people around anything that is of that level. I mentioned the RCMP investigation that we did. We had multiple sources, and we test their credibility.
So coordinated disinformation campaigns placed against a Canadian journalist who is trained not to a regulatory standard but to Canadian standards, what we know to be an independent free press, would not be successful in your view?
I think, I can only speak for the CBC, but we have a series of checks and balances, both in terms of our journalistic practices and our sort of values around these things. So there are checks and balances all the way through.
Yeah, that's very helpful. What can you tell the committee about generational divides in terms of how people get their news, what their preferences are, what their appetite is for investigative journalism?
I'm going to surprise the committee to tell you that millennials are actually interested in journalism. CBC News digitally reaches 52% of millennials in this country, and they consume it in a different way. They consume it not on television and not on radio, but maybe in podcasting and certainly on their smartphones. So but we see different generations going to different places to consume news. That piece is really real. But we see the younger generation still having an appetite for information and news, and that's heartening.
And the last question, Mr. Chair, with your indulgence, is there a gender component in investigative journalism? When we look at specific areas, such as, for example, work in the area of women in the sciences, technology, engineering, and math, if somebody were to write an investigative article on the state of affairs in Canada, are there particular aspects that women journalists would face that require either greater levels of protection or would the bill as it's currently framed be satisfactory in terms of the protection of sources from a gender perspective?
So I will take that as the woman on the panel. I will say that we have fantastic female investigative journalists, and we see no gender imbalance in terms of the nature of who does this work. But we were concerned with the framing that I referenced in my opening remarks in Quebec around Marie-Maude Denis in terms of implying relationship was part of the tools that she used in terms of her journalistic trade. So, but in terms of people practicing, we have quite good gender balance in investigative work.
I'll just add that they may feel more vulnerable to sexism and to innuendo. But at the same time, Marie-Maude Denis and Isabelle Richer, the two women journalists who were caught in this fishing expedition, just want very strong protection for every journalist, regardless of sex.
And just if I could to add a little bit of extra context in terms of the state of journalism in this country. First of all, as the panel's resident millennial, I suppose, I'd like to say that my generation does consume news ravenously. There's more of an appetite out there for news than there ever has been. The problem is that in our country, the news industry has literally been decimated, if not more than that. And I mean that in the literal, like a tenth has been destroyed, probably quite a bit more than that. I cut my teeth at Maclean's magazine. When I was there, I believe there were 50 people working in the editorial side of the newsroom. Now there are approximately 15. And that's in a matter of 10 years. So that's a frightening decline that we've seen all across the country. And whereas I like to look at it kind of as if the journalism industry in this country was once, a forest or a jungle and unfortunately large parts of that have been completely burned to the ground. What that has left is some fertile soil, and there are some new things sprouting up, and there are a lot of organizations that are doing really wonderful things despite these challenges. I think CBC is an excellent example of what we've had, but the same thing with the Globe and Mail, the Toronto Star, the Legacy Media. But the thing is, there is still a massive hole there in this country, and people are ravenously devouring content, but there isn't as many people providing good quality content. There's more noise and less signal out there than there has been, and they're also, because sources are drying up, because of we need legislation like this in order to give journalists as much of a fighting chance as they can, and to make this pillar of democracy as strong as possible. So taking away those sources by not having a shield law is a serious issue.
1 minute.
Very, very, very briefly, would you, given your most recent comments, would you consider us being at a stage where we now have a structural concern with respect to the health of Canadian democracy?
Yes, I would certainly say so. We funded the News Poverty Project at Ryerson University. I would encourage everyone to take a look at that if you want to see a stark example of how many dozens of newspapers and broadcasters and online outlets have closed and how few have opened across Canada in the last 5 or so years. Thank you very much. Thank you.
That has really come to our time for debate, but Mr. Brassard, if you have some questions, I'm happy to give you 5 minutes.
Thank you, and I'll only take a couple, Mr. Chair. I actually find it kind of ironic as we sit in this room and you look straight ahead and you see a mural of the printed word, and then if you look over your shoulder, you see another mural. So clearly the importance of journalism and the freedom of the press is important with respect to our democracy and really builds on that openness and transparency. As I've sat through this debate, I've heard that Canada, with this law, will go from laggard to leader with respect to the SHIELD law. And so I'm just wondering, based on your experiences with other news organizations in the United States, for example, and others, and other Western democracies, how important is this to Canada based on that experiences of these other countries?
Well, as a former foreign correspondent, I'll take that question. You know, I was correspondent in China and Russia, not paragons of the free press, and you realize at that point how lucky we are to operate as journalists in a country like Canada, despite some, shortcomings. So, this is essential, I think, to the image of Canada in the world. The press now is attacked in places like Turkey, where it hasn't been attacked like before. Egypt is still a very big problem, the whole Middle East. So if on something so fundamental as the protection of confidential sources, we can't adopt the protections that are given to journalists in most Western liberal countries, then I think it's a real shortcoming.
And I would say at the end of the day, it comes down to the public who we're trying to serve. And at the end of the day, if sources don't come forward and the stories don't get told, we're doing a disservice ultimately to them.
Thank you. And Tom, just so you know, Porter Call, you've been bumped off your flight. Based on your opening comments.
Something tells me that I'm probably not going to be able to get on my flight back to Toronto this evening.
Thank you, Chair.
You're welcome. Ms. Damoff, do you have a question?
Thank you very much. I just have two very quick questions, actually. I think it was you, Mr. Cormier. Did you say that this bill was important to pass in order to protect the identity of the sources in the commission that's going on in Quebec? Did I understand that correctly?
No, what I meant is I wanted to say that the whole thing is kind of not contradictory, the exercise. Somebody brought up the fact that maybe we should wait until the commission finishes. You know, we have journalists in all Canada, not just in Quebec, so we need the same protections across the board. Whatever they come up with recommendations will be more than about a law to protect journalists. It has to do with, police work and ways to better, regulate the way they operate, and also the whole relationship between ministers and the police and sources and how that works. I think it's a broader view because the problem was bigger than just the sources or the journalists. But
and I don't know if I thanked all of you for being here, but thank you for being here. My second question has to do with the definition of journalist. And our previous panel spoke about how there was quite a lengthy conversation at the Senate that involved both the police and journalists, and came up with the definition that is currently in the bill. Ms. Maguire, did I understand that that this definition you can live with?
Yes, we're supporting this definition.
Okay. I think all of us recognize that perhaps the bill isn't perfect, but it's a gigantic step from where we are right now. And perhaps as we move forward, we can fine-tune that as we look at it. But I just wanted to confirm that you were okay with the way the definition was in the bill.
Yes, the coalition is supporting the definition.
Okay, thank you very much. That's all I had.
Okay. Do the Conservatives have any other questions? You're good? Mr. Dubé? Any others? So I think that we'll suspend for a few moments. Thank you to our panel of witnesses, and we'll be able to suspend for a few moments and then move to a clause-by-clause consideration of this bill. we can begin. Just before we begin, I wondered, has there been any news on Larry Miller's mother? Nothing? Okay, because I know that she was sick last week and he wasn't able to come, so I want to check on that. And just also to mention to the committee that apparently Diane Watts had an accident or an incident with her ankle and has hurt it, so that's why she is not here today. Sorry.
She fell outside the Wellington building. Is that what that was from?
Maybe that's what it is. It was I don't know when it was or where it was. All right, so we begin clause by clause now of the bill, and we welcome Mr. Wong and Mr. Noel, who are here to help us with any questions we have from the Department of Justice. And Mr. Mela is here as our legislative clerk to help us with any procedural questions we have regarding our clause-by-clause process. And so we are going to begin, and as is our custom, we will postpone Clause 1, the short title, and go right to Clause 2. As you can see from your amendment package, there are 3 amendments to Clause 2. I'm going to note to the committee that there was discussion about the eligibility of Clause 1 and whether or not it was within the scope of the bill. And I have read it and I have decided that yes, it is within the scope of the bill because the scope of the bill is broadly the protection of journalistic sources. So I think it is appropriate for us to begin with it. And I turn to Mr. Dubé if he would like to move that amendment.
Certainly, I move it, and I will defer to Mr. Enheffer's testimony as to why it's an important amendment to broaden the definition, given the changing media landscape, and leaving it, quite frankly, up to having that open criteria and letting the judge decide as is already prescribed by the bill. And I just want to add one last piece, Mr. Chair, is there was also testimony with regards to this being the current definition being acceptable, and I certainly don't disagree with that. But I'm not in the business of taking good first steps. We have a long way to go, and so if we can get there more efficiently and more quickly, I think that that's certainly our responsibility as legislators. So I move the amendment.
Is there discussion or comments about the amendment? Seeing none, all in favor of the amendment? Any opposed? The amendment is defeated. We move now to Liberal 1 amendment. Ms. Damoff.
Thank you, Chair. And I think I can say this about all of my amendments, so I don't need to repeat it. They all add further precision to what is in the bill already. Liberal 1 is removing the override provision so that it's not necessary, because it could conflict with other federal legislation, and it's not needed in order to give effect to the protection for journalistic sources that are in the bill.
Liberal 1?
Liberal 1, deleting lines 1 and 2 on
Right,
page 2. And I understand you have a comment on Part B.
Yes, just with respect to Part B, I have suggested that there are 2 incidences of a question of renumbering the lines, the subsections, and that is not necessary. There was some discussion among the clerks in the House and the Senate that it was required. However, Philippe has informed us that after those discussions, we've learned that that is not necessary as an amendment. So I understand you're not moving B.
That's correct. I'm only moving
So
A.
only A. Any discussion about Amendment Liberal 1, Section A? All in favor? Any opposed? It carries. Moving to Liberal 2. Ms. Damoff.
So again, on that one, I'm not moving D. And on this one, I'm just going to leave it at that it's providing further precision on the bill.
Mr. Dubé.
Yeah, thank you, Chair. I just want to say, just let me find the proper place where I am here. Yeah, excuse me. So we changed essential role to importance of the information, to the essential role of the information to the importance of the information, and central issue in the proceeding. I think that the language has become a little more vague, and so my reading of it is that it creates a little bit of a loophole that jeopardizes somewhat the mission of the objective, excuse me, of the bill, and so I'm voting against the amendment.
Any other discussion? Mr. Arsenault.
Juste pour commenter.
I'd just like to make a comment at this point. So it's in the interests of the public and of justice, but in light of the common law and what the Supreme Court of Canada has said and Pierre Roy has deemed possible, I have no problems agreeing with this amendment because it completely is in line with the decision handed down by the Supreme Court of Canada. So I support this amendment.
Any other questions, comments? Seeing none, all in favor of the amendment? Any opposed? It carries. Moving to Liberal 3. Ms. Damon. Oh, yes. Shall Clause 2 as amended carry? All in favor? Any opposed? That is carried. Liberal 3. Ms. Damon.
So Liberal 3 deletes any reference to any other act of Parliament. And the override provisions are not necessary to give effect to the protections for journalistic sources contained in the bill. And as I had mentioned on another amendment, it could conflict with other federal legislation. So I think I'll leave it at that.
Good. Any questions or comments on the amendment? Mr. Dubé.
Yeah, thank you, Chair. Once again, in my reading of the amendment, it does again create a lot of leeway for police in a situation where, as Mr. Carignan was raising, this whole notion of not knowing the person's a journalist, and I should probably just leave this as a ditto for a few of the amendments, but I feel the pendulum in Canada is far to one side, which is police powers, and there's very little given to journalists. And as we've heard, this is even only a first step, and so once again, voting against the amendment.
Any other questions or comments? All in favor of the amendment? Opposed? That carries. Liberal 4. Ms. Damoff.
So this one adds some additional subsections to ensure that the new test for warrants doesn't apply when the application relates to a journalist's criminal activity. It's reflective of, I'm going to leave it at that.
Any other questions or comments? Mr. Dubé.
Yeah, thank you, Chair. This speaks to an amendment actually that Monsieur Pratt brought to the Senate after hearing testimony of the Canadian Chiefs of Police. Well, it adds further to that. Considering the compromise was already acceptable, once again, as far as I'm concerned, going too far into the direction of leaving loopholes open for police. In this case, when it comes related to other offenses the journalist may have committed. There was a concern raised by the Canadian Association of Chiefs of Police related to, for example, someone who might have outstanding charges related to driving under the influence or something of that nature, completely unrelated to the source. But the ongoing criminal investigation into that journalist on another matter could be seen as a way to find a source. And so the bill was originally drafted in a way that completely isolated the two proceedings, which the police did not like. And so rightfully so, and Mr. Pratt had already found the compromise. I don't feel that going further in this direction once again is necessary.
Any other questions or comments? Seeing none, all in favor of the amendment? Opposed? That is carried. Liberal 5, Ms. Damoff.
So Liberal 5, sorry. Has to do with the powers of the judge. It introduces new subsections. And once a judge becomes aware of a warrant relating to a journalist, police would be required to inform the judge of Superior Court, refrain from examining or reproducing the evidence, and seal it until the Superior Court judge disposes of the application. Again, I think we're just adding some precision to it. I would say that as the bill went through the Senate, they didn't have the benefit of having justice officials look at this bill. So all of these, having had discussions with the justice officials, I think they're appropriate.
Mr. Spangman.
Thank you, Mr. Chair. I have a sub-amendment to the second portion of Lib 5, which is powers of a judge under sub 8. This relates to section 44, sub 1, sub 8. And I will read out the English. I'm told we have it in both languages.
So where is it going? I missed that.
So it's sub 8, which is 488 sub 1 sub 8, and in Lib 5 it's basically as powers of the judge, the first subsection of that. And the language in its entirety is on an application under subsection 7, the judge may confirm the warrant, authorization, or order if the judge is of the opinion that no additional conditions to protect the confidentiality of journalistic sources and to limit the disruption of journalistic activities should be imposed.
So it is a sub-amendment on 8A.
Correct.
With an additional sentence. Would the committee like to hear it read again? I think the clerk would. If you could read it once more and then give the clerk a written version of it, would be great.
So it reads in its entirety again. On an application under subsection 7, the judge may, sub A, confirm the warrant, authorization, or order if the judge is of the opinion that no additional conditions to protect the confidentiality of journalistic sources and to limit the disruption of journalistic activities should be imposed.
Okay, and could you get that to the clerk?
Yes.
So there's a question from Mr. Nicholson about whether or not that is actually indeed already covered in the amendment Part B, 8B.
Mr. Chair, Part B relates to the variance of warrants. This is basically just the initial step of confirming the warrant without any evidence to vary it. So they are two distinct approaches.
I'm just looking at the justice officials, whether you have any comment on that. Because you're here.
Thank you, Mr. Chair. I think 8A, the way that it's been moved in the sub-amendment, is basically a mirror of B, so it doesn't replicate the considerations in B, and the judge may confirm the warrant, authorization, or order if he feels like no additional conditions should be imposed to protect journalistic sources or the freedom of the press. So I don't think they're inconsistent or replicative of each other.
So B then stands, A mirrors the consideration in B and puts it into A as well. Am I clear on that?
Yes.
Okay. Mr. Brassard.
Is there any chance we can get a text of the amendment, the amendment that you put forward, Mr. Spangler?
We could suspend if that is your desire to get a copy of it.
I would like to see
it. Is I see it as handwritten.
Oh, is it? Okay.
It's what we turned out.
But it's well written.
It's fairly straightforward.
Would you like to read it? Do you want to?
Oh, okay.
Let's just take 1 minute for Mr. Broussard to read it, but don't move. I'll lose you. I think it is. We are considering the sub-amendment to a Liberal 5. Mr. Broussard.
No discussion on it, but if we are going to do the vote on this, we'll vote on division, please.
Okay.
Thank you.
Okay, so all in favor? Opposed? And it's on division. Okay. Now we're going to vote on the amendment as originally stated. If there's any more discussion about Liberal 5, it's as amended. All in favor? Any opposed? It carries. Moving to Liberal 6. Ms. Damoff.
This motion is being proposed to ensure that journalistic sources can be protected even when the journalist is under an investigation for criminal activity.
Good. Any comments, considerations? All in favor of Liberal 6? Any opposed? It passes. I thought my cold was gone. Liberal 7, Ms. Damoff.
This is just a purely technical, consequential amendment, and it in no way affects the meaning or effect of subsection 488.022.
It appears to remove a redundancy.
Yes.
All in any discussion on Liberal 7? All in favor? Any opposed? It carries. And the last amendment, Liberal 8. Ms. Damoff.
This motion deletes section 48803 override provision from the criminal code portion of the bill because it's not necessary to give effect to the protections for journalistic sources contained in the bill and could conflict with other legislation.
Good. Any questions or comments? Shall the amendment carry? All in favor? Any opposed? Carried. Shall clause 3 as amended carry? All in favor? Passes. Shall the short title carry? All in favor? Any opposed? Shall the title carry? All in favor? Any opposed? It carries. Shall the bill as amended carry? All in favor? Any opposed? It is carried. And shall the chair report the bill as amended to the House? All in favor? Any opposed? It is carried. And I will report it as soon as we are able to clean up the work. I think that completes the business to be brought before the committee. You guys didn't have to work too hard today. You should have seen the last officials we had here at a clause by clause. I heard. You got it easy. You owe them one. All right. Seeing no other business, the meeting is adjourned.